Good morning, everyone. I'm Art Coleman. I'm co-managing partner at Education Council and had the privilege of working with ACE and Pearson in the development of this report. I want to thank them for their tireless efforts on this important topic. And I'm very pleased to introduce Jamie Lewis Keith, who is Vice President, General Counsel, and University Secretary at the University of Florida, and was also the first in-house primary counsel at MIT. Jamie and I have been collaborators on this front for, I'm tempted to say decades, but I'll just say years. And share a common passion, sometimes finish each other's sentences, but bring some different perspective to the table. I regret that Melissa Hart can't be here today due to last-minute issues, and so as opposed to serving as moderator today, I'm going to be in a dialogue with Jamie. We're going to be talking about what we think about these issues. And so I want to start with, I think, one indisputable proposition: race matters. And then I want to build on that in light of this report to say research matters. And then to take Laurel's astute lens on that to say one step further, actionable research matters. I will tell you, often as the lawyer in the room on these conversations, I never consider myself to be the most important person in the room on these conversations. It is those who have the experience in the research to inform policy development. And so we're going to talk about this through both a policy and a legal lens. And because I know a number of you who are court watchers are sitting on the edge of your seats and you want to know what the court's going to do next term, the answer's in the envelope. Jamie and I are going to get to court prognostications before the end of the panel. But I don't want to get distracted by that, frankly, because the underlying work here is really what's important at this stage of the game. And so before we delve into court watching, I thought I would kick it off, and then Jamie is going to reflect on these observations with further thoughts. I've been working in this space for decades, and as I was reflecting about what to say at this panel, I began to develop a list of myths, a number of which I think are effectively addressed in the research report. But I want to give you 7 myths, and I want to dispel those myths that address both policy, practice, and law as we think through these issues. The first, the issues about diversity are, in the first instance, about what lawyers and judges say. So often I get the question, what would the court say about X? And what I want to suggest to you is that's the wrong question. Because what lawyers and judges have to say about diversity in higher education with respect to students stems based on underlying facts about what's important to an institution. What's the mission? What's the goals? What are the strategies? What are you pursuing? So the what, the why, and the how should be decided in the first instance not by the lawyers, but by the education leadership from the top down. It should be institution-focused, research-based, and faculty involved in core academic decision-making. So the homework, in a nutshell, rests with institutional leadership and actors. Myth number 2, the issues of diversity are just about admission and nothing else. I think Matt effectively dismissed that myth. But there is, as Gary alluded, an understandable tendency to think that when we're talking about these issues, admissions is the only thing we need to talk about. It is the only thing that garners headlines. It is the only thing that the Supreme Court has touched in its decades of looking at these cases. But it misses the forest for the trees. And I will tell you, and I think this is now surfacing in the Fisher 2, as we're now affectionately referring to it, that the broader enrollment patterns are highly relevant to the question of the lawfulness of particular practices, even in admissions, and we can talk about that. Myth 3, the issues of diversity are just about race and ethnicity. It is remarkable, even on campus, when you start talking about diversity, how that conversation quickly devolves into a conversation only on race and ethnicity. And as important as race and ethnicity is to that conversation, it is not the totality of the conversation. And the courts would tell you if it is the totality, then we have bigger issues. So the concern tied to the core educational value of diversity is that institutions look broadly and holistically at all of those factors that are important to them in achieving core, forward-looking, mission-driven educational goals. You saw some of these factors in the survey: family income and SES disadvantage, first-generation status, what I refer to as distance traveled, what the student has overcome. The report refers to it as grit. Where the student has lived in the United States or abroad, cultural experiences and particular competencies that a student will bring to the table. Those are powerfully important factors for those in the admissions business of assembling a class that will create the diverse kind of learning experience they want for the benefit of all students. And we should not lose sight of the fact that this focus on diversity, which includes but is not limited to racial and ethnic diversity, is for the benefit of all students. 4, myth. When deciding what strategies to pursue, it's either race conscious or race neutral. Again, Matt, you're on your way to a JD. We've got a full array of policies and practices, often not picked up by the press and increasingly not picked up by the courts, that show the practical realities that this notion of either or is a false dichotomy. When race plays, it is in the context of other race-neutral strategies and alternatives. That's sort of beyond question. So this is very much a both-and enterprise. We can come back to this in Q&A, but I would just flag, picking up on a couple of the questions that surfaced toward the end of the last panel, the notion that we also know in crystal clear terms what is race neutral and race conscious from the purpose of a legal opinion leaves a bit to be desired. The court has not been abundantly clear in defining that, and in fact, I think there's quite a legitimate debate about whether the Texas 10% plan in and of itself would be race neutral or race conscious. And so let's not assume that because a policy on the face of it is neutral, that it necessarily would qualify as neutral under a court opinion. Number 5, my personal favorite, and the one that Jamie and I have tussled with probably more than any other. Myth: we should stay as far away from numbers when talking about diversity as humanly possible, given the risk of being perceived as promoting quotas. I think the question translated, one of what is success and how do you know it when you achieve it, is probably the thorniest question institutions, from my experience over a couple of decades, and I think you see this play out in the Fisher litigation and in oral argument. One of the thorniest questions around. This question of success, I would argue, has to be numbers attentive. I have never encountered an admissions dean who was not numbers obsessed. So the notion that this would not be at least numbers attentive strikes me as flawed, but at the same time, it can't be a quota. And so the question is, how do we define in both some mix of qualitative and quantitative ways what it is we're looking for? And why is that such an important question for the courts? The courts disfavor reliance on race. And so if you're relying on race, they want to know that you have a mechanism that at some point in time you're going to be able to say, success, I no longer need to rely on race anymore. And for you to have that trajectory, you've got to have what I think is an effective contextual benchmark on which to evaluate success. So this is a big question, and I think the real issue is the blend of numbers and qualitative foundations for that. Myth number 6. We can rely solely on the research and evidence of other institutional practices to establish effective and legally sound practices on campus. That is a myth because every institution has the obligation to roll up its sleeves and do the hard work. I've encountered many institutions that said, oh, we don't need to worry about the educational benefits of diversity. The Supreme Court decided that in 2003 when they upheld Gruder's plan. Well, yes, they did, but they upheld that as a matter of fact with respect to what was important to and supported by evidence at the University of Michigan. So the best analogy I can suggest to you non-lawyers in the room is think about defending a dissertation. You have a proposition you want to prove, and you are certainly going to beg, borrow, and steal from other research in the arena. So we're going to look to other social science research, as Laurel rightly notes. But other social science research will not establish the proof points that are necessary in an institution-specific context. Finally, myth number 7. Courts and pundits are equipped to step fully into the shoes of admissions experts. There are quite a few, some on courts and some in the press, who think they are more than qualified to tell admissions officers what they should be doing. It will not be a surprise to anyone in this room that I think they're wrong, because I think fundamentally people outside of the academy lack the mission orientation. They frankly lack the expertise, and they lack the faculty engagement, which is so essential to getting it right as a matter of the educational enterprise. And so I think the question is, why then is everyone an expert? For most of us, we went to college and that makes us an expert, or we have a child going to college and that makes us an expert. But I want to flip it, because I want to suggest that that tendency by everyone to know what's best as a matter of admissions policy and practice, and this filters into legal conversations as well, is misguided, and we have something that we need to change profoundly in addition to a focus on more actionable research. We need to be more deliberative and transparent about what we're doing. I think there was a moment in time where it was where admissions officers were going behind closed doors, trust us. And I don't think we're in that era anymore. And nor do I think we should be running away from professional judgment that actually makes tough choices, balancing multiple factors. But if I reflect back on sort of decades of work in this space, I think the one area I would say we've really, beyond the absence of perhaps as much actionable research as I'd like to see, we have not been as transparent and therefore as compelling, not only to judges, but to the court in the court of public opinion, which is increasingly important in this enterprise as well. So I'd offer those 7 myths as a foundation for turning to Jamie and say, what did I get wrong?
Well, I won't answer that right now, Art, but I'll go on to say that Art's busted those myths, and now I'm going to focus on 3 structural concepts that I think are important in the success of diversity and access programs. But because I think Art and I and the courts agree that context matters, I'm going to first very quickly set the stage with 3 matters of context. The first is that this is clearly an area where an institution needs to navigate some challenging legal landscape. And I just want to share with you that I think law is to access and diversity what gravity is to aircraft design. And that is, it is a design parameter. It is something you need to understand and address in order to be successful, but it is not the driver, and it is not the objective, and it has to be in its proper place when you're thinking about this kind of important work. The second is that there's an enormous variety of institutions in the United States in higher education. That's something this report and all of us know clearly. And it's both the sameness and the uniqueness of each institution that in part drives why a particular institution needs diversity in order to achieve mission, and also what outcomes, and I do want to stress outcomes, diversity can achieve in a particular institution, and also what means that institution uses in order to achieve its diversity-related goals. And third, as a matter of context, is, and as Art alluded, increasingly the court of public opinion is really pivotal through the political process. And I think it is true that institutions of higher education have not been very effective in communicating broad social interests in diversity to non-higher education audiences. In 2013, the births of people of color exceeded the births of white people in the United States. And for many years, people of color and women have been the fastest growing segments of the college-age population in the United States. At the same time, there is an increasing gap in poverty and education opportunity in our country, and that has disproportionately affected people of color. And this is particularly true in those fields such as science and technology that offer the greatest opportunities. There is a substantial interest in all members of our society, of whether broadly recognized by the public and the courts or not, and it's really incumbent on us to be able to communicate in a way that it will be understood, to stop wasting abundant intellectual resources and increase educational and career opportunities for the fastest growing segments of our population. And while institutions of higher education support internationalization and welcome with open arms international members of our campus communities, and we should continue to do so, if the largest and the fastest growing segments of our population are not as equipped to participate in the global economy as the citizens of other nations are, and if those students who are educated in our institutions are not well equipped to go out into a very diverse world when they graduate, then there is a very serious problem for all citizens of our country, and that's going to impact many people. So it is true, I think, that institutions of higher education have a very important role to play in effective diversity efforts to address these and many other issues. And I'll also say that I do think that social justice issues are extremely important for our institutions to remember and not abandon. But I'm simply saying that it's also important to focus on unifying messages that resonate broadly in society and in the courts, and regardless of differing views of what is just and what is not just. So that's the context. And with that context in place, I just want to go on to the three structural concepts that I think are helpful in these initiatives. And the first is really to ask a series of questions when you are designing these programs. In light of an institution's authentic objectives, and those are some that are common across higher education or a particular segment, as well as those that are unique to the institution, what scope of diversity is being sought and for what purpose? In other words, what are the educational, research, and service outcomes at the institution and by the institution that will derive from diversity and are related to the institution's mission? And a corollary to those questions are really what climate and what programs, what level and quality of interaction among diverse populations are needed in order to retain a broadly diverse community at our institutions and to foster the sought-after experiences for all students, the benefit to all students, as well as to realize other positive impacts of diversity. And then a second set of questions is related to how you will measure the effectiveness and impact of diversity strategies in terms of their ability to help you realize these kinds of outcomes that you are trying to accomplish. And recognizing that there is a resource issue that has been alluded to in the discussion today in conducting this analysis, what kinds of both qualitative but rigorous processes and quantitative data are needed in order to assess the impacts and effectiveness of various options. And I would say that if you can, it's useful to go through that analysis not only on the race-conscious initiatives that you have in your institutions, but also for those so-called neutral strategies, so that you can really be allocating your resources, which are scarce, to those things that are really going to have an impact. And if you can answer these questions well and actually document those answers, you're likely to both satisfy your real policy objectives, which is the real world reason we're doing this, as well as put yourself in a much stronger position to defend the actions that you're taking from a legal perspective. And I think also in answering these questions, institutions can allocate those scarce resources more wisely. Concept number 2 is that partnerships are critical, and there are many different types of partnerships. Partnerships of policymakers and lawyers, people who are committed to the diversity objectives of the institution and have the knowledge and expertise from both a policy and a legal perspective to not just say no, but rather to chart a path forward that is both wise in addressing some of the challenges and also effective in the real world results. And that's something that's powerful. I see Shirley Malcolm here today, and AAAS, the American Association for the Advancement of Science, had a diversity and law project and published a design guide which is intended to really support this kind of active partnership, and there are many other resources on their webpage that came out of that effort, which Art and I worked on as well. The second kind of partnership that I'd highlight are partnerships of institutional stakeholders, and faculty are really critical. I don't think faculty have been as engaged in these kinds of discussions on campus as they need to be, and they are really central to using diversity to realize educational benefits. Once you've achieved your objectives in the admissions office, how is that going to be utilized on campus, and what is the impact of that? And it also involves administrators, trustees, students, alumni, industry, and again, lawyers who are well informed. And these kinds of partnerships are really important so that diversity is not just an add-on, but that it's really woven into the fabric of what is excellent about education, what is excellent about the research and other activities of the institution. And then partnerships among both similar and different institutions that are complementary, and perhaps at the same and different levels of the education pipeline, which can collaborate in order to expand the opportunities at every stage of the pipeline. I think in the report it was noted that there is more research that needs to be done to see why that kind of pipeline expansion activity can't be more effective, and I do think that would be very worthwhile. And finally, and there is in the AAAS diversity materials, there's a smart grid and a recruitment consortium which are tools for that. And then finally, the partnership of institutions of higher education with industry and military, local communities, and others who can really expand the perspectives and public understanding of how diversity in higher education serves important economic prosperity, national security, democratic process needs, and other really important societal interests of all students and of all members of society, which brings me to the third concept, the third structural concept, which is that in light of our environment, effective communications are really critical and must resonate with the general public and the courts of law, not only with education audiences, and we really need to call on our partners in other sectors to do some of the communication and advocacy for broad societal interest in diversity at colleges and universities. And institutions of higher education really need to be able to speak more effectively to a broader audience than themselves. So with that, I will stop, and Art and I are going to turn to the Fisher case and our read of really what's going on with the court's second review of the Fifth Circuit's second upholding of University of Texas at Austin's admissions process.
So I'm just going to, in the interest of time, jump right in, and then Jamie's going to weigh in, and we will open it up for questions. I'll just say this on Fisher. I recognize there's a lot of consternation about the fact that the court's taking the case for a second time. I actually Googled Fisher a couple of days ago just to see what's out there, and the number of headline predictions, affirmative action is dead, is a sort of staggering prediction in that computer window. But consistent with my contrarian disposing of myths, I'm not going to pretend to precisely know what the court's going to do, but I'm going to give you some points on why I think it's unlikely this Supreme Court is going to overturn basically the Grutter regime that was built on Justice Powell's opinion in Bakke going back to 1978. First, let's not lose sight of the fact that we actually have, over the course of the last 4 decades, 6 majority opinions of the U.S. Supreme Court that in one form or fashion have acknowledged the educational benefits of diversity as compelling and justifying in appropriate, limited ways race-conscious practices. And in fact, you had in a K through 12 case in 2007, the entire court sort of making that recognition. That doesn't mean the court's not going to step in tomorrow and say, whoops, we got it wrong. It's been known to happen. And I think there are 4 justices on the court who are poised, frankly, to take that step if you read their past opinions. But the doctrine of stare decisis should count for something. And in this context, there is a sort of adequate foundation there on that foundation. The practical punchline here is simply this. It's all about Justice Kennedy, really. It just is. You've got 4 justices on the court who have consistently articulated, and I hate these labels, the sort of the liberal position. You've got 4 justices that are pretty rigorously posed to not like anything they're looking at that reeks of race consciousness. And Kennedy is a remarkable centrist. He's emerged as the centrist. He's been the decider, as it were. I'm just going to read you one line from his opinion in the K through 12 case, where he said, "The enduring hope is that race should not matter. The reality is that it too often does." He actually, much of that opinion was a recognition of the challenges and the role that race has got to actually continue to play as we think through policies that are race attentive or race sensitive. That said, when it gets to the question of not the ends you're pursuing, but the means you're pursuing, he tends to be very conservative and very rigid in terms of practices he will pursue. But I think he is a centrist of sorts in this context. Jamie?
And I think he seems more comfortable with macro-level concepts of race consciousness than he does with individualized assessment. He talks of zip codes and 10% plans, those kinds of things he is more comfortable with. But I think that there's an opportunity in this case to, even in the kinds of research that was done in this report, to really demonstrate that there are pervasive practices that are happening, that are necessary, and they're not being done on their own. They're being done in a much larger context. And I think there is some reticence in some of his opinions about completely upsetting major important activities in society too precipitously. So I do think the kind of work that was done in this report will be helpful in the analysis.
And then I'll just say one final point, and then subject to any final comments Jamie wants to make, we can turn it to questions. I think there is a tendency within the higher education community, having lived through a couple of rounds of Supreme Court briefs, we'll let all the national organizations carry the water on the importance of diversity. And as important as the message of ACE and other national organizations represented here are in expressing the voice and the importance and the compelling need for some appropriate consideration of race in some institutions that pursue diversity goals. I would ask all of you, particularly those of you representing institutions of higher education, do not lose sight of the power of your particular voice. If you go back to Bakke and look at Justice Powell's compromise opinion, it was premised on an amicus brief that was submitted by Harvard. So as Justice Powell is striking down the University of California Davis policy, he's saying, but I like what those guys over there at Harvard are doing, and I like it so much I'm attaching the entire policy to my opinion. That's power. If you go to Justice Kennedy's dissenting opinion in Grutter, he was not part of the 5 to uphold the law school admissions plan, but he was a solo dissenter to say, I believe that the educational benefits of diversity can justify the limited consideration of race. And by the way, University of Michigan Law School, if you were doing the kind of thing that Amherst College, in its amicus brief, told us they were doing, then you might be okay. And so I think there is power in the ability to tell a story, which we are not known for doing terribly well, about the work we do and why we're doing it and how we're doing it, both to educate the court, and this is about educating the court, but doing so in a way that also illustrates the rich tapestry of the varied institutional policies and practices that may have common themes and common goals, but really vary case by case, and I think that would be helpful in this litigation coming up. Jamie?
I think the only thing else that I would add at this moment is just that that in thinking about things like critical mass and thinking about where a justice such as Kennedy would be looking, and he is looking at the close tie, the narrow tailoring of the goal which he supports and the means to get there, if it's a race-conscious means. And so, as Art alluded, we've had debates about whether that should be a range of some kind of overall numerical goal, as was the case in Michigan Law School, or whether it should be something that is more an outcome of the presence of a good mix of students in diverse students in your classrooms and in various majors throughout your campus, and whether that is something that you could have a rigorous process around, where you are actually tapping into student reflections and faculty reflections on whether there are enough students of various backgrounds who are present in order to allow each student to really fully participate, which benefits all students, and not be marginalized, et cetera. If there are ways qualitatively of actually measuring that in a rigorous way, because the court is looking to be able to tie those means to the ends. There has to be an end, and I think that's something that is probably the highlight of what Justice Kennedy was dissenting on in the Grutter case.
So with that, let me invite folks in the audience here to come up to the microphone. And while you're doing that, I will start with questions that have already started to come in from our colleagues across the country. Jamie, this is not a plant, but I'm going to give you this one. How do we as a field define quotas if that's illegal, and how do we define success for achieving diversity? So I think it is the question of avoiding quotas, but doing so with sufficient there. What's your best advice on that front?
Well, I think that while, again, this is something that is somewhat resource intensive, I do think that it is important to understand from faculty who are out there teaching, from students who are experiencing things in classrooms, from alumni who have gone through your institution and are now out in the world, and from individual students really, whether when they are participating in class, when they are in your system, they are able to fully participate, whether they feel marginalized, whether they feel that they are representatives of their race, or whether they are acting as individuals, and whether students have actually had an opportunity to have real interactions in the classroom, in co-curricular activities around campus with people different than themselves. So it really goes to how are you using diversity on campus, and how through interviewing, student evaluations, some surveys which can be formal or informal, how you can really document that. And I think you can document it in meaningful disciplines. So in science and technology disciplines, many times there are very strict curriculum requirements, and those students don't get to go out and take as many elective courses where they may get exposed to an entire campus. So one thing that an institution can do, instead of just measuring the diversity across an entire campus, is to actually look in those particular disciplines and look at survey results and student evaluations and things like that within that discipline, as well as looking at more broadly. And I think there are some practical ways you can do this with less labor intensiveness, like on the Harry surveys and so forth that all of our institutions participate in. Make sure that you have some specific questions that will go out to your students that will give you some of that information, and let some of the deans and others that are really looking at whole discipline areas reach out to their alumni, get alumni to actually speak to you and document what they have to say about how important it is to hire people into their companies who have had that kind of diverse experience on your campuses.
And I think there's an element of a kind of punchline there, which is if we're leaving the educational benefits of diversity up to the enrollment officials, we are not doing our job. There has got to be, to use a policy wonkish term, a through line from the entire enrollment enterprise to the student experience, both in academic or student affairs. And without that, I think we open ourselves up to a sort of political correctness argument, which might be quite right, and more fundamentally just haven't fulfilled the promise and the theory that we aspire to in this context.
Which is why faculty are really important,
Hugely.
obviously.
Yes, sir.
Art and Jamie, I think all of us were grateful for your prognostication that the court is probably not yet ready to change its mind on affirmative action, and that there's no evidence in particular that Justice Kennedy is going to renounce what he said before. But you can't be too sure, as you certainly acknowledged. So what are the means by which those of us who believe deeply in the affirmative action as it is now practiced can tell those stories, can get the information before the court in time for Fisher 2? I know that prior to the Michigan decisions of 2003, the University of Michigan itself took the lead in collecting Friends of the Court briefs from industry, education, the military. Is any organization or institution taking responsibility for bringing together the stories that you have rightly called upon us to tell?
I think it's because we're sort of in the very early stages of the, oh my God, they just granted cert. All of that has not been settled, and I don't want to speak for ACE, but I would be shocked if we're not, Molly, moving together to try to help coordinate, certainly.
I would applaud that if you would take that on. I think that'd be great.
Line level. And I think that's really important, and it is about telling the stories and making sure those stories are fully told.
And making sure they are diverse stories, because regardless of what the court does, if it's, these are very fact-specific decisions, just as our institutions are different. So really tying it to your specific institution and why it works or wouldn't work there is important.
So I've got a question here coming. If we could explain briefly exactly what Texas did that is at core being challenged. What's the challenged practice, factually, Jamie?
The specific factual practice is that in Texas, as we all know, there's a 10% plan. So the top 10% of all graduating high school students across Texas can be admitted to the school of their choice. And because Texas has fairly racially segregated communities, that results in a certain amount of diversity. And then about 20% of the class, or a small percentage of the class, relatively speaking, is then admitted through a holistic review process that takes into account both academic credentials. So, for instance, in certain very high-performing schools, there may be very academically accelerated students who are not in the top 10%. So those kinds of facts come to play. And then also a personal achievement index, which takes into account more of a holistic person. What is the experience in life? What are the personal kinds of accomplishments? And that's where race is taken into account as one of many factors. But the individuals who actually give a score for personal achievement are not the individuals who actually draw a line on a matrix to decide everyone above this line, everyone who has an academic achievement score and a personal index score above this line is going to be admitted, and everyone below is not going to be admitted. So there's no awareness of whether race is involved or not. And then I think the question is what is the end that the university is trying to achieve in its admission process, and how much impact does that does that approach have? Because the numbers are small that are admitted through that process, but the percentage of various student groups is larger than the numbers. And I think one of the issues, so two issues that I'd just like to highlight from this case are that, number one, do you want to know, is it good? In Michigan, they were very aware of the racial composition of the student body as it was being admitted. In Texas, they took an approach, I think, which has lesser impact of race, lesser consideration of race, really, where they didn't know when they were admitting the class. And another set of issues is what was the objective? So is critical mass defined by some kind of a quantitative measure, which Michigan did in part. Michigan said there was some kind of a range it was looking at, but it was also looking at the qualitative effect of students of diverse students on campus. And Texas really didn't as much define that. So I think that those kinds of issues are the ones that are likely to be heavily focused on in the case.
Yeah.
Good morning. I'm Elizabeth Morgan from the National College Access Network. We represent underrepresented students of color, low-income students, students who will be first in their generation, first in their families to graduate from college. I understand the parsing of the goals for institutions. I understand the interest of the justices and wanting to know, well, we need to see what the goal is so we know when you can stop using race. But I just feel very compelled by the discussion this morning. Why can't our goals be bigger? Why can't our goals, even for selective institutions, be not just to set some sort of critical mass on campus? We want students to be comfortable. Why can't we reflect the diversity of our country? Why can't that be a goal for a national selective institution? To represent the diversity that we find among all of our population across the country, or within our state, if we're a state institution, a public flagship. Why can't we reflect the diversity of Maryland or Michigan or Texas? Why can't that be our goal?
I think part of the answer is that in part it can be, and in part the court has said it can't be. And the part that we can consider, and I think you're right, for flagship institutions who have a very strong commitment, which have a very strong commitment to their states, the demographics of their state, and any institution, if you look at the reach of your institution, the demographics that you're trying to reach are very important, and they can be considered, and institutions can look at these larger societal interests that we're trying to serve by the education that we provide to our students. But I think what the court has said is that to simply say, and I don't really think we ever really do simply say this, but to simply say that we want to reflect in our student body the same population representation as is reflected in our state of particular groups, that is just what the court has determined is racial balancing and is not constitutional. But that doesn't mean that you can't look at the demographics of your state or the demographics of the nation to say, we have a very important responsibility as institutions of public and private education to educate students, to prepare them for citizenry, to prepare them for the workforce, to prepare them for leadership, and to serve economic strength, national security, and many other culture and many other interests in our society. And so we need to be aware of whether the individuals we are educating reflect the individuals who are out there in the world that we're trying to serve. And so I think it is absolutely appropriate and legal to consider those demographics. It's just not okay in the same way that it's not okay to have an absolute quota to say, I'm just targeting that number. I don't know if that answers your question.
And I would just say in amplification, I don't think the court's constraints, again, this is about ends and means, and the court is clamping down on means. They are saying, we sort of defer to you on your defining your mission and what your goals and what your broad educational interests are. We are not in a position to second guess that fundamentally. we are going to rigorously review the methods by which you achieve those goals when those methods include race and ethnicity. And so I think to the extent you have strategies, designs that don't include that, it's a, I'm probably slightly overstating it, a go for it strategy. It is the question and the sort of the blood pressure of the lawyers in the room will go up when questions of race and ethnicity conscious practices surfaces. And again, to be clear, it doesn't mean they're illegal. It simply means you've got to navigate this terrain where the federal courts pose challenging but not insurmountable questions that can and have been addressed by institutions across the country to achieve their goals. Sir.
Yeah, I think my question actually builds right on that. Not to get too far in the weeds, I'm Jeremiah Quinlan. I'm the Dean of Undergraduate Admissions at Yale, so I'm one of the admissions practitioners in the room that is scratching his head over all of this. And the words that we've scratched our heads the most over in the last 2 years is sort of workable race-neutral alternatives.
Yep.
That's just a head scratcher. And I would love to hear your legal opinion or just your professional opinion on what you think an institution has to go through, how far down the path do we have to go to evaluate workable race-neutral alternatives. To connect this to the graphs over breakfast presentation from earlier in the morning, it didn't surprise me that selective private institutions haven't gone that far, because I'm not sure it's clear to us that we are required to explore all the way down towards the nth degree whether or not a race-neutral alternative is going to be workable or not. And then my second question is on that is, my feeling, not legally informed, is that Kennedy wants to be more prescriptive. And he wants to really start to enunciate the means to achieve the ends. And I'm not sure he'll be able to do that with the other people on the bench to really get that prescriptive, so I have no idea how this is going to end up. But is it worth even an institution right now driving ourselves nuts for the next 10 months going down that path if the prescription is going to be given to us in June?
So I'll start. It's a very fair question, and I should acknowledge at the outset that different institutions with different resource constraints can come at this question in a lot of different ways. So I'm not going to try to sort of opine from on high there. Let me go to actually your underlying question. What in the heck do we mean by workable race-neutral alternatives? And for those who may not be familiar, this was part of the requirement that the court in Fisher imposed that was a sort of addendum, if you will, to what the court in Grutter had done a decade before, where it basically said we need to see real exploration, consideration of workable race-neutral alternatives to make sure you've really explored and expired alternatives before you turn to race. And this was classic Kennedy, if you go back to his dissent in Grutter. I will tell you, I don't think there's a magic answer. The court did not do a great job telling us what they thought they meant. I will tell you there's a corresponding guide we put out here, and there's a whole page on race-neutral sort of strategies that we've published that you may want to reference. I will tell you this just in a nutshell. I'm a pragmatist on these issues, and I sometimes step back from the details of the case to say, what is the court really looking for? And I think what the court is really looking for is mission-based, deliberate, authentic, hard conversation and judgment over time that would, if I'm making the case, show them I'm being quite attentive to their rules, but it's not a sort of zone of impossibility. And so to just use you and a particular example, there may be a cluster of 5 to 50 race-neutral strategies that you as an expert might look at and go, wow, that's interesting, it might have play. If I'm your counsel, and by the way, none of this is legal advice. If I'm your counsel, I'm going to say, you know what? Find your team and go explore what's really viable or potentially viable, and then come back with some grounded recommendation. You, by the same token, may have that cluster of the Texas 10% plan. Not going to work so well for Yale, given our sort of who we are and what we do. Do you need to go try a 10% plan? No. So I think there is an underlying rule of reason that shouldn't take us off of the rigor of the analysis. It almost goes back to my dissertation point. But I think there is an underlying practicality that if you can then, and I'm a big one for transparency and documentation, not all council are, document that process over time with rigor. The fact that you didn't pursue some, half-brained schemes that might work, 4 states over but would never work for you is not the kiss of death. Jamie?
Yeah, I agree, and I think that's I agree with document. If you're going to use a race-conscious approach, then you should be able to document all the other things that you're doing and I think the report shows many institutions are, and I do think even Kennedy did acknowledge the fact that institutional judgments on what's workable and what's not workable will be honored. As long as you are also showing that you're not just saying off the cuff, nothing else is going to work, but that you've actually looked carefully.
Sure.
See, I don't have to get up here and talk about grain size because you've already done that. Usually I'm the person who comes up and says, you can't just look at a total institution, and I want to look at the STEM part of campus because that's usually where the problem is. But apropos the last question, what about the use of technology to actually simulate some of these? Where are things that are out there that use data mining and where in a much shorter period of time you can in fact apply algorithms that give differential weight to different things and then look at what the results might be for your particular institution. And I'm wondering about the acceptability of these kinds of tools to the court where you are not personally making all these choices, but you're letting the computer basically generate different classes and looking at, with different weighting, and then looking at different outcomes.
I think that's an intriguing and very fruitful path to consider for sure. I think that if there's more that can be said about that, it should be said. And I also think that there was a question earlier about outreach kinds of efforts and whether those were efforts that would be okay in a state that bans consideration of race in admissions and other programs. And I think institutions can do, and I'm not a mathematician, but multivariable regression analyses that show that all things being equal, race does make a difference, and that you're not giving a racial preference when you have special outreach programs, but you're actually putting people on equal footing. Now, again, that's not legal advice, and I'm not saying it's risk-free, but I do think that it is that it's a fruitful path to go on. So technology and computational kinds of things are helpful.
So we are at our time. I want to thank everyone for your, oh, sorry, you got one more?
I work with art, so I'm allowed to butt in if I want to. Returning to Jeremiah's question, his last question, is that would you recommend that institutions kind of sit on their hands for the next 10 months till we get a decision, or could they see this as a moment of opportunity instead?
Jimmy?
I'm not going to answer your question. I think that Fisher told us what we were supposed to do, and I think that that some efforts to go down that path are helpful. I also think that changing everything in 5 minutes is not something that you can do wisely, and I wouldn't recommend doing something that is sort of useless and silly.
So I'll go back to my favorite 2 words out of the Supreme Court that Laurel echoed earlier: context matters.
Yeah.
I think what you do as a matter of institutional practice very much depends on where you are at this moment in time. And I think there is roll up your sleeves deliberation. I know a number of institutions represented in this room are actually engaged in that work right now. But I'm also with Jamie. If you haven't been paying attention to this for 2 decades and now all of a sudden are in a hurry up and rush, I'm not sure I would be the one to say, 10 months, how long is that in the context of where you've been? So very much an institutional judgment.
But you can there's some getting organized that
Absolutely.
is worthwhile as this case looms in front of us.
Thank you very much. We'll take a 15-minute break and then be back at 11:15.